Hello everyone, welcome back to our Learning Legal English through Case Law series. In this video, we will study Case Law LUhet/2021/AL on determining the statute of limitations for filing a counterclaim.
Including 5 parts. Part 1. Source of the case law. Part 2. Overview of the case law. Part 3. Content of the case. Part 4. Assessment of the court. Part 5. Rules.
This case law was adopted by the Council of Judges of the Supreme People's Court on November 25, 2021 and announced in Decision Number 594/QDC dated December 31, 2021 of the Chief Justice of the Supreme People's Court.
Part 1. Source of the case law.
Cassation Decision Number 10/2021/KDTMGDT dated September 14, 2021 of the Supreme People's Court in Hanoi on the commercial business case dispute over the design consultancy contract in Hanoi between the plaintiff Joint Stock Company H and the defendant Design and Construction Company Limited P.
Part 2. Overview of the case law.
Case law situation. In civil cases, defendant has counterclaim against the plaintiff, person with related interests and obligations have independent claim. Legal solution. In this case, court must see counterclaim of the defendant as a request for lawsuit and must comply to relevant regulations on statute of limitations thereof.
Keywords of the case law.
Counterclaim, determining statute of limitations.
Part 3. Content of the case.
According to the lawsuit petition filed on June 24, 2010, and the process of settling the case, the plaintiff H Joint Stock Company, presented by the representative. On January 29, 2008, H Joint Stock Company and P Design and Construction Company, Ltd. executed a design consultancy contract number 01-2008/PLC HDC, with the content, Design and Construction Company, Limited P, Consultant, is responsible for designing the entire project commercial center 4-star HD hotel on a land area of 8,971 square meters at D7, Ward X, District T, Hanoi City, whose investor is H Joint Stock Company. The total contract value is $1,754,550, excluding value-added tax, paid in 3 phases of implementation. Phase 1, Construction Design, Stage 2, Interior and Landscape Design, Stage 3, Author Supervision. Accordingly, in Phase 1, Design and Construction, the design fee is $1,191,822, denoted as A. Author Supervision fee is $62,728, denoted as AA, divided into 12 installments, from first payment to 12th payment, in which, first payment, 25% XA right after signing the contract and the consultant has submitted the bank certificate of contract guarantee, insurance contracts to the investor, second payment, 5% XA after submitting the master plan design dossier and architectural plan to the investor and approved by the investor. Third payment, 10% XA after submitting the master plan design dossier and architectural plan to the Hanoi Department of Planning and Architecture or equivalent competent authorities and the above documents get reviewed and approved during the implementation process. Phase 1, Construction Design, P Design and Construction Company, Limited has submitted to H Joint Stock Company insurance contracts, bank guarantee of contract and design dossier of master plan and the architectural plan of the project. H Joint Stock Company has transferred payment to P Design and Construction Company, Limited 02 times. First payment, 25% XA in value added tax, according to value added invoice number 008190 days, February 27, 2008. Second payment, 5% XA in value added tax, according to value added invoice number 008190 dated August 18, 2008. The total amount of the above two payments is $396,751.75, equivalent to $6,374,689,675 VND, converted at the VND/USD exchange rate at the time of payment. After that, due to the project scale change and the two parties could not agree on the adjustment of the contract value for the new design, H Joint Stock Company unilaterally terminated the contract and had a dispute with the company P Design and Construction Ltd. over the payment value. H Joint Stock Company believes that in the first payment, H Joint Stock Company has advanced the payment in excess of the actual workload that P Design and Construction Company, Ltd. has performed. Therefore, H Joint Stock Company only accepts to pay P Design and Construction Company, Limited an amount that accounts for about 8% of construction design fee, 8% XA, for both payments, first and second time. In addition, H Joint Stock Company accepts to bear a penalty equivalent to 1% of the contract value because H Joint Stock Company unilaterally terminates the contract. Therefore, H Joint Stock Company filed a lawsuit to request the court to force P Design and Construction Company Limited to return to H Joint Stock Company the amount that H Joint Stock Company had overpaid to Design Company Limited. P Design and Construction P is $278,841.80 after deducting the amount advanced from the amount paid. P Design and Construction Company, Limited did not accept the plaintiff's claim use. This was the amount that H Joint Stock Company had paid to P Design and Construction Company, Limited according to the agreed schedule in the contract, not in advance. In addition, P Design and Construction Company, Limited has filed a counterclaim, requesting that H Joint Stock Company, in addition to incurring a fine equivalent to 1% of the contract value due to unilateral termination of the contract, the company H must continue to pay to P Design and Construction Company Limited the third payment, 10% of design fee, because P Design and Construction Company Limited has completed technical support to get approval for project's design dossier. P Design and Construction Company, Ltd. believes that the failure to submit the design dossier to the competent authority, leading to this design dossier being not approved, is entirely the fault of H Joint Stock Company. In the first instance, Business and Commercial Judgment Number 01/2011/KDTMST dated June 20, 2011, the People's Court of Hong Kong District, Hanoi City decided, accepting the petition of H Joint Stock Company against P Design and Construction Company, Limited demand P Design and Construction Company, Ltd. to return to H Joint Stock Company the advance amount of contract Number 01/2008/PLCHDC signed on January 29, 2008, $272,571.41 equivalent to $5,642,228,187 VND. Refuse counterclaim of P Design and Construction Company Limited against H Joint Stock Company. On July 1, 2011, P Design and Construction Company Limited appealed the entire first instance judgment. In the Appellate Business and Commercial Judgment Number 27/2011/KDTMPT dated September 21, 2011, the Hanoi People's Court decided, not accepting the appeal of Design and Construction Company Limited P, uphold the decision of the preliminary judgment. After the appellate trial, P Design and Construction Company Limited has applied for cassation review for the above appellate judgment. At the protest decision number 60/2014/KNKDTM dated September 15, 2014, the Chief Justice of the Supreme People's Court protested against the Appellate Commercial and Business Judgment No. 27/2011/KDTMPT dated 21/September 2011 of the People's Court of Hanoi City, requested the Economic Court of the Supreme People's Court to conduct cassation trial in the direction of annulling the above appellate judgment and annulling the first instance business and commercial judgment No. 01/2011/KDTMST. Dated June 20, 2011 of the People's Court of Hong Kim District, Hanoi City, hand over the case to the People's Court of Hong Kim District, Hanoi City for retrial in accordance with law. At the cassation decision number 18/2015/KDTMGDT dated March 26, 2015, the Economic Court of the Supreme People's Court decided, abrogate the appellate business and commercial judgment number 27/2011/KDTMPT dated September 21, 2011 of the People's Court of Hanoi and the first instance business and commercial judgment number 01/2011/KDTMST dated June 20, 2011 of the People's Court of Hong Kim District, City Hanoi Street, hand over the case file to the People's Court of Hong Kim District, Hanoi City for retrial in accordance with law. At the first instance business and commercialization judgment No. 32/2019/KDTMST dated November 25, 2019, the People's Court of Hong Kim District, Hanoi City decided, 1. Refused the petition of Joint Stock Company H against P Design and Construction Company, Limited to force P Design and Construction Company, Limited to pay back H Joint Stock Company the amount of 6,308,478,665 dong. 2. Partially accepted the counterclaim of P Design and Construction Company, Ltd. to force H Joint Stock Company to pay P Design and Construction Company, Ltd., as of November 20, 2019, the following specific amounts, plus, third payment, according to Design Consultancy Contract No. 01/2008/PLC HDC dated January 29, 2008, 1,599,420,000 VND, plus, compensation, according to Article 2.8.5b, General Conditions of Design Consultancy Contract No. 01/2008/PLC HDC dated January 29, 2008, 406,704,690 VND, plus, the interest of the amount of 1,599,420,000 VND, 2,080,735,870 VND, total, 4,086,860,560 VND, 3, in addition to the amount H Joint Stock Company must pay to Design and Construction Company P as above. Joint Stock Company H must also pay to Design and Construction Company P the interest of VND 1,599,420,000 from November 21, 2019 until the payment is completed at the interest rate of late payment agreed by the parties at 12% per year. 4. For the compensation amount, according to Article 2.8.5b, General Conditions of the Design Consultancy Contract 01/2008/PLCHDC dated January 29, 2008, of 406,704,690 VND, from the date of P Design and Construction Company, Limited has filed a request for judgment enforcement until the payment is completed by H Joint Stock Company. H Joint Stock Company must also pay interest on the remaining amount of the judgment at the rate of interest prescribed in Articles 357 and 468 of the Civil Code 2015. On December 9, 2019, P Design and Construction Company Limited and H Joint Stock Company both filed an appeal against the above-mentioned first instance judgment. In the Appellate Business and Commercial Judgment No. 82/2020/KDTMPT dated 15/19/6/2020, the Hanoi People's Court decided, amend the first instance commercial business judgment No. 32/2019/KDTMST dated November 25, 2019 of the Hong Kim District People's Court on how to declare the obligation to bear interest on late judgment execution. 1. Not accept the claim of H Joint Stock Company against P Design and Construction Company, Limited to force Design and Construction Company, Limited to return the amount of 6,308.478.665 VND. 2. partially accepts the counterclaim of P Design and Construction Company, Limited H. Joint Stock Company must pay P Design and Construction Company, Ltd. the following amounts: 1,599,420,000 VND, payment amount of Phase 03 of the design consultancy contract, plus 2,080,735,870 VND, interest on late payment, plus 406,704,690 VND, penalty due to unilateral termination of the contract. Total, 4,086,860,560 VND. On November 2, 2020, H Joint Stock Company filed a request for cassation review of the above appellate civil judgment. At the protest decision number 02/KNGDTVC1KDTM dated March 2, 2021, the high-level People's Procuracy in Hanoi protested against the appellate business and commercial judgment number 82/2020/KDTMPT dated 15+19/6/2020 of the People's Court of Hanoi, requesting the Judicial Committee of the High-Level People's Court in Hanoi to abrogate the above-mentioned appellate business and commercial judgment and abrogate the first instance business and commercial judgment No. 32/2019/KDTMST dated November 25, 2019 of the People's Court of Hong Kim District, Hanoi City, hand over the case to the People's Court of Hong Kim District, Hanoi City for retrial according to the provisions of law. At the cassation hearing, the representative of the High-Level People's Procuracy in Hanoi proposed that the Judges Committee of the High-Level People's Court in Hanoi accept the protest of the High People's Procuracy in Hanoi.
Part 4. Assessment of the Court.
1. Regarding legal proceedings, in the power of attorney dated October 1, 2015 and the power of attorney dated March 16, 2016, Mr. S. is currently the legal representative of P Design and Construction Company, Limited. Authorize Mr. D and Mr. N to participate in the proceedings as authorized representatives of the defendant. However, the verification results at the Immigration Department at official letter number 9089/A72P4 dated August 10, 2015, official letter number 14733/A72P4 dated December 11, 2015 and official letter number 9443/QLXNC-P4 dated June 12, 2019 determined Mr. S exited on October 18, 2014. There is no information related to Mr. S's entry and exit during the period from August 1, 2015 to August 1, 2015. June 7, 2019 inch. Thus, there are grounds to determine that by the time Mr. S signed the power of attorney for Mr. D and Mr. N to participate in the proceedings, Mr. S was not present in Vietnam. In case these power of attorneys are made and sent back from abroad, according to the provisions of Article 478 of the Civil Procedure Code, they must be notarized, authenticated, and consularly legalized to be valid. Besides, the determination at the time of making the power of attorney whether Mr. S is in Vietnam or abroad is also related to the consideration and determination of the jurisdiction to settle the case. The Court of First Instance and the Court of Appeal have not clarified these contents but have accepted the value and content of the power of attorney, while the plaintiff also requested the court to verify the authenticity and validity of the power of attorney, is a serious breach of the proceeding. 2. Regarding the counterclaim, the judgment of the Court of Appeal in Judgment Number 82/2020/KDTMPT that the counterclaim is not limited by the statute of limitations for initiating a lawsuit, page 15, is not correct. According to the provisions of the Civil Procedure Code 2004 and the Civil Procedure Code 2015, a counterclaim is a request not included in the claim of the plaintiff, which can be resolved by an independent case. The settlement of counterclaim in the same case is for more accurate and faster settlement results. A counterclaim is also a petition to initiate a lawsuit, so it must comply with the statute of limitations for initiating a lawsuit. Therefore, in case there is a counterclaim and a litigant in the case proposes the application of the statute of limitations for initiating a lawsuit, the first instance court and the appellate court must determine whether the counterclaim still has the statute of limitations for initiating a lawsuit or not in accordance with the law. 3. Regarding the content, according to the design consultancy contract between the two parties, the condition to receive the third payment is after submitting the master design of the total ground plan and architectural plan to Hanoi Department of Planning and Architecture or equivalent competent authorities, and the above documents are verified and approved. The case files show that, after receiving official letter number 992008/CVHD/QLD dated September 3, 2008 from H Joint Stock Company announcing the cessation of printing of design drawings due to scale change of the project, increase the number of floors. P Design and Construction Company, Limited has approved the content of this notice of H Joint Stock Company, so on September 29, 2008, P Design and Construction Company, Ltd. sent document No. MLS/HD/29/9/08 on proposal of design fees for high-end hotel project H to adjust the price for the new design. Because of not being able to reach an agreement on the adjustment of the contract value, H Joint Stock Company unilaterally terminated the contract ahead of time. The two parties dispute over the settlement of consequences of unilateral termination of the contract. H Joint Stock Company believes that it has overpaid to the Design and Construction Company, Limited P in the amount of $278,841.80 after deducting the amount advanced from the paid amount, so it sues to reclaim it. P Design and Construction Company Limited does not agree with the lawsuit request of H Joint Stock Company and has a counterclaim to force H Joint Stock Company to pay the third payment under the contract and penalty for contract violation. Seeing that, Joint Stock Company H has unilaterally terminated the contract under the provisions of Point G, Article 2.8.1, Part 2, so according to Point A, Article 2.8.5, Part 2 of the Design Consultancy Contract, it reads, upon termination of the contract under Articles 2.8.1 or Article 2.8.2 of the General Conditions of Contract, the parties shall agree on payment for consultant the income in accordance with Article 6 of the General Conditions of Contract on the basis of consulting services which have been performed satisfactorily and approved by the investor before the effective date of contract termination. In addition, the investor does not have to pay the consultant any other amount, except for Article 2.8.1.g, the investor will compensate the consultant equivalent to 1% of the contract value. Therefore, it is necessary to base on the value of actual workload that P Design and Construction Company, Limited has performed to serve as a basis for determining the payment obligation of H Joint Stock Company. First Instance Court and the Appellate Court and the Court of Appeal did not require P Design and Construction Company, Limited to present documents and evidences to prove the actual workload that P Design and Construction Company, Limited has performed after the second payment of Phase 1 prescribed in Article 6. 4 of the Design Consultancy Contract, partially accepted the counterclaim of the defendant, forcing H Joint Stock Company to pay the Design and Construction Company, Limited P 1/2 the amount of the third payment under the contract, corresponding to 5% of the construction design fee, is incorrect, affecting the interests of the plaintiff. 5. Therefore, the protest of the Chief Procurator of the High-Level People's Procuracy in Hanoi is grounded, so it is necessary to abrogate the entire appellate judgment and the first instance judgment for a retrial.
Part 5. Rules.
Pursuant to Point A, Clause 1, Article 337, Clause 3, Article 343, Article 345 of the 2015 Civil Procedure Code, 1. Accept the protest decision number 02/QDKNGDTVC1KDTM dated March 2, 2021 of the Chief Procurator of the High-Level People's Procuracy in Hanoi. 2. Abrogate the entire appellate business and commercial judgment number 82/2020/KDTMPT dated 15+19/6/2020 of the People's Court of Hanoi City and abrogate the entire business and commercial judgment 32/2019/KDTMST dated November 25, 2019 of the People's Court, Hong Kong District, Hanoi City on the case dispute over the design consultancy contract between the plaintiff, a joint stock company H with the defendant, Design and Construction Company Limited P. 3. Hand over the case to the People's Court of Hong Kong District, Hanoi City for resettlement according to first instance procedures in accordance with law. Case law content. 2. Regarding the counterclaim, the judgment of the Court of Appeal in judgment number 82/2020/KDTMPT that the counterclaim is not limited by the statute of limitations for initiating a lawsuit, page 15, is not correct. According to the provisions of the Civil Procedure Code 2004 and the Civil Procedure Code 2015, a counterclaim is a request not included in the claim of the plaintiff, which can be resolved by an independent case. The settlement of counterclaim in the same case is for more accurate and faster settlement results. A counterclaim is also a petition to initiate a lawsuit, so it must comply with the statute of limitations for initiating a lawsuit. Therefore, in case there is a counterclaim and a litigant in the case proposes the application of the statute of limitations for initiating a lawsuit, the first instance court and the appellate court must determine whether the counterclaim still has the statute of limitations for initiating a lawsuit or not in accordance with the law.